This is a really interesting case regarding the concept of apprehended bias, which is a substantial issue in administrative law, even though in this case it was a judge and not an administrative decision maker at the heart of the dispute. The case was a class action by shareholders against a company called Centro Properties. The judge in this case, Judge Finkelstein, had a practice of checking before every case whether his self-managed superannuation fund held any shares in either of the litigants. He wasn't personally involved in selecting the shares for investment. There was an advisor who did that. In this case, the conflict checker missed out one section of the shareholders and didn't notice that the judge's self-managed super fund held 2,400 shares out of the 800 million shares there were in Centro. Thing is, the share price had nosedived, and so those 2,400 shares equated to a $19,000 loss. This put the judge in a unique situation. As a shareholder, he was part of the class which were the plaintiffs in the matter. As part owner of the company, he also had an interest in the defendant. And when he sold the shares in order to remove that interest, he incurred the $19,000 loss, which meant that he had lost real money. Initially, the judge's opinion was that since his shareholding had been so very small compared to the overall number of shares in the company, there was no need for him to recuse himself. However, he reflected further on the arguments put by counsel and said, "My view was that the lay observer would appreciate that judges would be able to decide cases fairly, even if they were victims of the actions the subject of the complaint. It is, I suppose, possible that the lay observer would see things differently. The problem, I think, is that it is sometimes difficult for a judge to know what a lay observer might think about a particular issue. Moreover, a closer reading of the High Court cases suggested that it is not necessary to establish a high probability of bias to demonstrate that a reasonable apprehension is real, but instead some lower probability will suffice. As a result, Justice Finkelstein recused himself, and from this case, we learn that for apprehended bias to be present, there need not be a high probability that the reasonable person would apprehend bias.